We're talking about an important subject to get this session going. This is a question I'm asking both of you. Would you say is international justice possible? Normally, I need to introduce you. We heard you this morning, Philippe Sands, but I think you both were introduced this morning. Just a reminder that both of you are lawyers. Both of you plead before the International Criminal Court. Philippe Sands is written many books, in particular returned from Nuremberg, and Mr. Keita, you joined the International Criminal Court in January 2017 as the main counsel for the events. You were the founding member of the International Centre in Africa for French-speaking lawyers. You were the experienced mediator, and you were a judge at the International Organization of the Francophonie here. So you can see how rich our debates will be. So I think, Mr. Keita, you can answer the first question, and then afterwards Mr. Sands. So the question is, do you really consider that international justice is possible? Thank you very much for introducing me, and I'd like to thank you all for being present. I felt quite emotional when I visited the museum this morning, and in particular as it concerns children here. We tend to see opinions become extremely banal, and words become extremely banal, and very extreme words are just become mainstream. It's reassuring to see that there are many of you present in the audience here. We've got people here that are the guardians of our shared and common heritage, us as mankind. To answer your question, or humankind, this is the status of Rome here. Oh yes, an international justice is possible, and it actually exists. It's not easy, and it was created nearly 20 years ago. It's called the International Crime Court, which I've been with on a regular basis for 15 years. It's the first that meets the principle of fundamental law, which we all as jurists have wanted to create. So no crime, no justice is possible without law. Now, before we judge or assess or evaluate a person, we have to consider law. Now, this court, this tribunal, has got an ancestor, and that ancestor, and those are the Tokyo jurisdictions and the Nuremberg jurisdictions. I would say this ancestor was considered at the time, and even nowadays, a bit like the justice as established by the winners here. And the people would say, you committed the same crimes as we did here, and you weren't even allowed to allude to that during the Nuremberg Trial. Now, instead of talking about the justice of the winners, it's the justice organized by the winners. Let's put it that way. We can imagine the Allies and the defeat of the Allies, and if the Nazis had decided to judge the General de Gaulle, probably they would have found him guilty. Now, Nuremberg, without being perfect, be it for the prosecutors or for the advocates, at least within a year it had the merit of establishing the foundation of the International Criminal Court, and after 1 year the decisions were made. Now, obviously, we can't be proud in terms of the reviews. The procedures are long. If we consider the International Court of Justice, the procedures aren't necessarily understood by the greatest number. We say that the court is a political court, but at least it's got the merit of actually existing. It's a necessary evil. It's what we call judicial dissuasion. Since this court, International Court of Justice, exists, the criminal court exists, when the crowds are walking towards the powers, the people in power, at least the people in power don't shoot at the crowds here. It doesn't mean that the International Court cannot be created or cannot be criticized, but it's a great initiative. Before this initiative, the initiatives had been those of the United Nations and a resolution creating following the massacres of the ex-Yugoslavia crimes here. After the genocide in Rwanda, we had a resolution by the United Nations in 1994 to create an international court. That's what we call a reactive justice. So it's a disaster, and we want to repair by establishing law. So no crime can exist, no punishment can exist without law. And finally, it's the International Criminal Court that will respect this great principle. We get together, the states on a voluntary basis accept, based on a treaty and an agreement, the existence of this court. And it's a permanent court. All the others are ad hoc courts. The special court for Lebanon will be closing down in the coming months because there aren't the necessary means and resources. Now, to get together and to be stronger, that's the greatest act of sovereignty as far as the states are concerned. The fact that they are willing to be stronger together by abandoning part of their sovereignty to decide that at the international level that the victims will have a place. The International Court has enabled this for the very first time, to decide that these crimes, there's no possible prescription here. That's the International Court, to actually decide that regardless of the quality of officials, and that's Article 27, by the way, whatever who you are, king, queen, prime minister, president, your immunity cannot be opposed to this institution. They have actually prosecuted two heads of state, Alain Bashir, that led to us being obviously being frowned upon by the African countries, but nobody can ignore the very existence of the International Court of Justice. We are criticized for just being a colonial tribunal because we're just pursuing the head of states. Now, obviously, if it were so, I mean, I'm proud of my African origins here and even from part of France, but I can say it's totally unjust to say that the International Criminal Court is criticized of being a colonial court. It started in 2009. They decided to prosecute really a head of state who was still in office here. Now they're saying, yes, but you ratified it, you actually agreed, didn't you, here? And they all started to become afraid here. And then the propaganda was created against the court, the international courts. I mean, it's okay when you're talking about warlords and prosecuting them, but how about prosecuting heads of state still in office? That wasn't seen as being as positive anymore. So the International Court is there, justice exists. You cannot develop as a state in a situation of civil war. And if we need to put in place peace through justice, the International Criminal Court is there, and they can install peace and enable development. Those who are elected officials, they're there to protect us. That's their first duty. When you've got a crime against humanity, I mean, the last century, we were walking on the moon here. We're starting to walk here, the wrong way up here. We're talking about men, women that are raped. Obviously, we cannot have a situation where people are not punished. And personally, I refused the stamp to the International Court, Criminal Court. Why? Because to actually fight against people who are not brought before. But I'm there as an advocate. I'm not a prosecutor. I'm fighting again for justice and not. And justice means we have to be fair and equitable here. And the defense needs to exist. And the International Criminal Court hasn't yet been able to get up to that particular level where we actually protect a certain number of things. Yes, I just wanted to, just one last minute to say, we can criticize a lot of things about this International Criminal Court, that they're just prosecuting part of the planet. No, we just prosecute individuals, not states. We can criticize it, that it's got a big budget, but if you consider its ambition, this budget is nothing. It's 149 million euros, which is nothing when you think about it. When we criticize it, that it gets involved in things that it isn't considered. Why aren't they prosecuting in Israel or elsewhere? But they do. Now, for some of its members, they are punished by Americans, by the Americans, for example. So from Nuremberg to The Hague, you will see at Nuremberg that Americans were ahead. They were ahead in terms of the prosecution. In terms of the analysis, in fact, this morning I found out that after Nuremberg, there were other American trials that were organized by the Americans targeting certain doctors. And today the International Criminal Court hasn't succeeded in bringing together the great powers. If we consider that those who've got a right for veto, it's only France and England who have ratified it. The Americans haven't ratified it. China hasn't ratified it. Russia hasn't ratified it. India, Pakistan haven't. Israel. And it's your commitment, it's your engagement, it's your support that will maybe one day make sure that these countries consider that they should belong to the process. We need to believe in justice, believe in international justice, and even though it's not perfect, it's at least got the merit of existing. Thank you, Nuremberg, for having opened up this possible approach, even though it's far from being a perfect approach, and that we're pursuing this nowadays, even though it's not perfect, but at least it's got the merit of existing. No sentence, no crime without law, and nobody ignores the very existence of the International Criminal Court, and they consider genocide, crime against humanity, crime against aggression, and war crimes. And that's since September 2002. Before this did not exist, because now we know that law exists, and if you infringe that law, you face your responsibilities. Thank you very much. Thank you very much. There was a lot in your presentation. You talked about criticizing the International Military Tribunal. Here we're talking about the justice of the winners, because usually the justice of our winners is to actually shoot those who have been judged, whereas that's what we taught at the Faculty of Law, and then afterwards you showed that the International Criminal Court has shown that it is possible to have an international justice, even though it is not perfect. What do you think about it? I would say an international justice, is it possible? Well, yes. Is it the case nowadays? No, not really. We fully recognize that international justice, and the word in English is the long game, basically. It actually happened in 1945, thanks to those who negotiated and adopted this particular status with the prosecutors, the judges. I'd like to pay tribute to all the judges, including the judge Henri Donjou-Deval, that did an amazing job. A very specific situation. What they did, they opened up a door here. And when I'm trying to see where this door can lead us, I always remember two anecdotes two stories. The first one was about 25 years ago. I was a young scientist, a young researcher at the University of Cambridge at the St. Catherine's College, and there was a professor there. I was very close to it, John Baker, a professor of history of British law. Every 6 or 7 weeks he would invite me to have lunch to find out what I was actually working on, and I would tell him such and such a thing, X, Y, and Z. Then he would think, and he said, "Oh yes, Philip, oh yes." And we had that problem in British law. We had it in the year 1472, and it took 275 years to sort out that issue. And that is to say, you can't create an international law in 1945. The principles, the rules, the processes. Now imagine that 75 years later, everything will not be sorted out. It's one step forward, a step to the left, to the right, another step backwards, then 2 steps forwards. It's the long play, and it's going to take hundreds of years to really imagine a true international justice here that would apply to everybody. It's only in 1947 that for the very first time in British law that we were allowed to intend an action against the Queen. So very, very recent. Second story.
When I was in Washington, D.C., I was doing a conference at George Washington University with Thomas Bogentag, a leading American judge, and who had been at the International Criminal Court for 9 years. At the age of 10, he had been at Auschwitz, and he was amongst a group that was subjected to Joseph Mengere's treatment. And so we were doing a conference on the future of international justice. And 2 weeks later, I was preparing to go to the International Court to plead in the case for the Rohingya and Gambia, the Rohingya against Myanmar. And at one point, Thomas Bergenthal turned to me and he said, "Can you imagine, Philippe, that in 1944, if we'd had a situation where there was a convention against genocide and a small country far away wants to take action against Germany?" Well, that was unthinkable. So can you imagine? Think of that difference in 75 years. So it's not perfect, you're right, but it's remarkable nonetheless. And something else you said that really touches me. It's clear that all of what was done at Nuremberg has served international justice. We know there are problems, and we know that there also new crimes have been added to the list. We know that some have been applied retroactively, but we also know that there was only one type of defendant during the Nuremberg, so there were only the Germans, in fact, and Germans and some Austrians. And so this created lopsided justice. So I'm not sure I can say that in French, but so there was no balance here. And so what I fear is that, in spite of what you said, that we still have a very big problem in The Hague. If you go to their website, and you look at the identity of the 46 individuals who have been indicted before the International Criminal Court, they are all black, they are all African, and yet they do not have the monopoly on international crimes, and this is deeply troubling. For example, in Afghanistan, since 2002, there have been many allegations made on all sides, in fact, between the Taliban, the government of Afghanistan, the United States, the British. But nothing has happened. Why not? Well, we know why not. Because of power. Because power is everything. And so, yes, the door has been opened, and it's opening a bit wider. But, in my opinion, and it seems like it's going to be a very long journey. So, Mr. Keita, yes, I would like to say a few words. So I'm going to have to, I'm a defense attorney, so I'm going to defend the International Criminal Courts. I mean, you know how cases are brought before the court. Well, there can be at the initiative of a prosecutor or a state that might refer a case, and then we investigate. And during that investigation, if we have reasons to believe that certain things have been committed by a person, then it goes to a preliminary chamber who must issue and validate a warrant for their arrest. And then, if we look at some places on the planet, and we might say it's been devastated and we don't know who the perpetrators are, well, there is nonetheless the Security Council, which acts as the police of the world, and this is the Article 7 of the United Nations, United States, France, the UK, and with the approval of the international community, well, might be asked to intervene, such as what happened in Libya. So I make that aside to say that if we look at today's picture, it's true that all the people currently indicted are Africans. For me, as an African, we have to arrive at a situation in which we remove impunity. But we have to do this everywhere. It's true. And so I'm certainly not blaming the fact that right now it's all Africans. So my question is, are there victims in Africa? Yes, there are. And so then we must abide by our word. And it's not just because there are crimes elsewhere that we must not pursue the crimes brought to us. And the African states are amongst the first to bring cases before us. When in 2008 there was the anniversaries established, and I was asked, you know, when it's Europeans that preside the court, you know, things happen a certain way. And I have said to them that 3/4 of the cases brought before the court were referred to us by African states themselves. In Uganda, the Congo, the Central Africa, even Mali, came to The Hague, Ivory Coast as well. And when Ouattara came to power, he referred a case to us, and then the Ivory Coast joined the Rome Treaty. And Gbagbo, I attended the first hearing of President Gbagbo. He had referred cases to us from 2003 because we have accepted the statutes of Rome. And so I can't sit here and let you say that there are only Africans before the courts, but we, our Africans themselves, have referred cases to the court. And so, once again, elected officials, their main duty is to protect us. And so I'm very proud that it is Africans who have referred cases to our court. And so this should help us to institute order on our continent, because that is what we need. So I'm going to. So this might be a bit provocative, but well, what do you say to that if we're going to be provocative here? Well, now it's Mr. Sands' turn. Well, yes, the court has its competence, but, you know, it's, okay, this was my response. Okay, yes, but I'm not entirely satisfied with this answer. If we look at Afghanistan, well, I can tell you something about Afghanistan. I was one of the first prosecutors, and I was asking, well, why is nothing being done on Afghanistan? And I was told, you know full well why we're not doing anything. We know the reality. And so we have to be aware of this and speak openly about it. So little by little, you know, we have the example of Afghanistan, and what about the situation in Iraq involving the British? There was no trial there. And those have been set aside. Those cases have been set aside. So this bothers me. I find this you know, I see this lopsided justice with great despair. And we're still doing the same thing as what we saw 75 years ago. Law is like a spider's web. And yes, who are the spiders? Well, they're catching the small ones, but the big ones are getting away. So I think that's the reality of our current world. I thought you were going to quote Victor Hugo to do with the powerful and the miserable. Well, I'll give you a proverb from Mongbara, from Mali. The day might be far away, but it doesn't mean it's not coming. So we have to be optimistic. We have to believe in what we're doing. So just take it easy, step by step. We'll get there. Okay, yes, there's Afghanistan. And some members, you know, the prosecutor has just stepped down, was prohibited from traveling. A judge at our criminal court who was opening investigations at Afghanistan was subjected to mistreatment by the Americans, prevented from traveling. And so I've, you know, on the Afghanistan situation, there was a lot of hostility toward our attempts at investigation. So, and other situations that haven't yet come before the court, but where we expect to be investigating in Colombia, in Georgia, the Republic of Georgia, in Afghanistan. We're trying. It's not just Africa. And in Palestine, the case has been opened, but the big powers are protecting their allies. And one thing I would like to criticize my court about is that we need to be looking at ourselves, what about being the gendarme of the world, being the police of the world? We have to play that role. This has worked in Sudan, so I found it scandalous that we could see those massacres going on in Syria because one of the great countries vetoed any action. And so that is a political action that paralyzes our court. And so I really wonder why, 75 years after Nuremberg, we still have these vetoes. In the name of what? To protect certain powers? You yourselves should be denouncing this veto rather than saying it's the court but that's in the Rome statutes. It's imperfect, but that veto power exists. And in Article 16, we're trying to give peace a chance. The Article 16 means that any party may say that reconciliation is possible, and the Security Council can suspend investigations for a year, which can be renewed. So that is a way, for example, that Kenya opted for, where some high members were being investigated, and it gave and then the Kenyan population became very anti-court and driven by their leaders, and then the opponents gathered together and took over Kenya, but they continued to cooperate. They came to the court, they came to the hearings, and they continued with their ordinary activities. And then, as you know, the charges were dropped because when you're in power, the penal court has no police or army. It has no law enforcement teams. So, a country might just be pretending to cooperate. And so the prosecutor at the time had preferred to drop the charges rather than to arrive at an acquittal because those indicted little by, kept moving around, changing their identities. And so, when witnesses were called, it wasn't possible. And in the papers, we were hearing that so-and-so would be testifying against our head of state. Of course, the witnesses would not go if they had been identified. I've been identified, even though I tried to hide my identity, and so they were afraid. And so that is a weakness of the court. But that's a reality, but you can't blame the court for that. We don't have the resources. We don't have an army. And, we all together created this court, and we fund it. You all fund it. But at the same time, it's best to be a part of this Statute of Rome, be part of this court, than rather stand outside it and criticize it. Well, I'd like to change the tack of the conversation a bit. So here we're talking about the international level, but that's a rather small portion of the work. That's not where things really happen. Where they really happen is domestically. And so this type of conference, we tend to forget that. looking at what's happening within each country, or things that might not come into the newspapers or that isn't in different languages. For me, this is where we see some things going on. It's not necessarily at the international level. Let me give you an example. Which country is pursuing the leaders of Daesh, of the ISIS? There are various trials underway that are very interested on crimes of genocide by rape of women. No one's talking about that. No one is talking about the consequences of the international travel of great leaders under the principle of international competency. What happened when the Americans began in 2003 or 2004 of being accused of waterboarding? Nothing happened at the international level, but at the national level. Some prosecutors began conducting investigations, and because of these, some leaders of the country were unable to travel. Mr. Rumsfeld, for example, he no longer left the United States. Mr. Bush, who was supposed to go to Canada and Switzerland, canceled those trips because two prosecutors indicated that it would be possible that they could be questioned on the point. Then, so if we look back to Nuremberg, the most important of the trials that followed was not an international trial. It was at the national level. And that was against Senator Pinochet. Why? Because like at Nuremberg, this was revolutionary. For the very first time in history, a national court in the UK indicated that in the context of an international crime against humanity, a former head of state no longer has immunity. That was extraordinary. And the outcome of that, the impact of that was enormous, because this hindered the ability to travel of all those called for questioning. So if we ask that question, is international justice possible? I don't think we should be focusing only on the word international. Yes, we also, at the International Court, recognizes complementarity. But it's really at the national level that so much can change. And I think in the coming years, that is where we need to be putting our focus. But is universal justice possible? And then in that sense, there could be complementarity between a national or state-driven justice or international justice. Well, when we're talking about international justice, we're also talking about crimes that are also being raised at the national court level. And we forget sometimes that once you have signed the Rome Convention, it does imply changing domestic law. And they must be transposed. All of the crimes of the international law have been transposed to national law. And the UK did this to include crimes against humanity. We had a genocide from the 1948 Convention. And so there's a lot of complexity at play here. But this, I think, this is why we shouldn't just be looking at what's going on at the international level. Do you agree with that then, Mr. Keita? I fully agree with Mr. Sands. I would like to remind you that the International Criminal Court in the Rome statutes speaks of complementarity. And so the European jurisdictions, before seizing them, so you have to go via the national courts and appeals courts, etc. And so that lies with the states. And so when we say that the International Court, for what it's doing in relation to the African states, I mean, the African states should be thanking the International Court because it means that there was no complementarity, but it is up to the states to investigate. But if they can't, or if they don't want to, or if they are pretending to do this, to try to protect certain ministers, for example, it's only in those cases they can take over and decide to conduct its own investigations. So we talk about international criminal justice, but it provides for the primacy of the domestic court system. What's unfortunate is that some states that might be concerned by the nature of these crimes are developing countries and don't have the means to offer a justice that is independent, devoid of corruption, that has modern mechanisms for the organization of the judicial system. They don't have the means. And so this is why we speak of positive complementarity. And what we mean by that is that we must help the countries that need it to train judicial officers. And so ideally, we would have no work at the International Court because the states would have their resources to pursue investigations and trials. But we are far from that situation. And so the international, yes, it must be there, but we must begin always at the national level. And that's all the more reason why the African countries cannot be blamed. All right, so we've reached some form of agreement here, so that's already quite an achievement. So let's just take one or two questions. I know we're running a bit behind schedule, but do we have one or two questions from the audience? As we know, the first question is always the most difficult. I mean, because I have plenty of questions, but this is your chance in the audience. All right, well, I'm going to go with my first question then. All right. Okay, so let's talk about how the international justice can be improved. We've talked about giving states the resources. Do you have any other suggestions for making international justice possible? Of course, with complementarity. Well, I have some suggestions, in fact. I have made these public statements, in fact. If it's the first court, is giving a voice to the victims, we must listen. If there's acquittal, and many feel that they are victims in a second time. This happened at the Bemba trial, at the Gbagbo trial as well, who were acquitted. But this is law, and the International Criminal Court is not a human rights court. Then we must seek the responsibility elsewhere. This is a prosecutor who didn't do his job. The defense attorneys were excellent, but the judges have decided. And so, we don't want to see people feeling victimized a second time. So we can't rely on this mechanism of the International Court alone.
way to be able to pay the victims back. The first responsibility in the case of victims is the state, because the state failed by definition. So it's up to the state to immediately indemnize the victims, even though they may be pursued in front of the courts. If the state can't, I mean, the victims need to receive compensation. Now, it's the Security Council who's supposed to be there as the kind of world police force. So it's the United States, which means the international community, all of us collectively, needs to repair, needs to compensate. It's up to the international community then afterwards to have a recourse when people are convinced or have been condemned here beyond any doubt. That would avoid the victims to be victims a second time. Let's face it, 3/4 of the people who are being actually put before the courts are considered as being indigent here. Thomas de Banga, the first person who was brought before the courts, he was condemned, but he's got assets. Well, what's he going to do? Is he going to say sorry to the victims? No, we need him to repair. This is a concrete proposal here, compensation. Second proposal is the duration of the procedures here. The right to the law of Rome was negotiated within a treaty. The community, the judges, the diplomats, the magistrates, they each tried to impose a law of origin. It led to a mixed law with an Anglo-Saxon approach here, with the participation of the victims. So it's a whole mix here, but this mix isn't the best possible outcome as such, because there's no initial truth, let's face it. The prosecutor is there to investigate. Here, I'm a defense attorney. Do you think I'm going to really... No, you can forget about it. So for me, as a defense attorney, I'm going to go locally to investigate, even though it may be 3 years later. And the victims as well, they are there to have truth come along. So we've got 3 truths that come along and that are put forward here. And we've got procedures and court cases that last 8 or 9 years. And then we're forgetting a principle, a fundamental principle, and that's the freedom is the rule, and it's imprisonment should be the exception. I mean, if it were an international court, a criminal court, where national here, they would be condemned. We need to reduce the time and the duration. We need to change the process of procedures and to really make sure that we have a kind of general attorney who deals with it, and then afterwards they investigate, and then afterwards we will have the defense counsel, prosecutor and the victims. They will have time to carry out their own investigations, and it won't last 10 years. It will be faster, not as expensive, and we'll have something much more satisfactory here. Those are my proposals. Thank you very much for your proposals. This will be, we started with you and we'll finish with you. That's great, but I've got the impression that we will be fiddling while Rome burns. I think there are issues that are much bigger out there. There's a total lack of a political will. In 1945 there was the definite political will. In the 1990s there was a political will as well. It was there. Currently there's no political will out there, and I think the most important, for the moment at least, is to advocate the idea of international justice, because it's not a given. We can see, and we were talking about this over lunch, we see what's going on in certain countries at the moment. At the moment, you can't go anywhere to talk about the Uyghur issue. Once a week I receive a request, what can we do about the Uyghurs? Is there a tribunal, is there a court? And the answer is no. The United Nations, they haven't even had access to the camps, the Uyghur camps. So if we're talking about international law or justice, for me, the focus shouldn't so much be on the procedures of certain instances and bodies at national or international level. The idea would be to cover a political will on the basis that no individual and no state is allowed to act in a certain way. But it's a great concern for me at the moment. For 4 or 5 years now, we've got this project pertaining to a project for preventing and punishing crime against humanity as a parallel convention agreement, like in 1945 regarding the genocide. This isn't going anywhere. It's been blocked. It's a deadlock at the UN level. It's amazing, those states, those countries that created the actual system in 1945, those countries, those states have lost the will, the determination to pursue their own project. So for me, the focus should be not at legal level, but at political level. We need to encourage those countries who did that much in 1945 and also in the 1990s to get around the table again, and to encourage those countries that didn't participate at the time but should be around the table now, including China, Russia and many other countries. And we need them to recognize that it's not acceptable to act in that way between 1933 and 1945, to act in that way, and it's not acceptable today. And I agree with you, there is a big issue if we consider the Security Council of the United Nations. It's totally ridiculous, and you can't defend it that in 2021 we've got these 5 countries can control the world agenda, the world calendar. And if we really want to open up the door, that's where we really need to start. And it's just with that kind of political will and determination, and with that kind of change, that we will be able to tinkle about with the legal bodies. The law never comes first. Law always follows, and law follows a political will and determination. If we really want to change things, that's where we really need to have our focus. And institutions like this one, organizations like this one, play a crucial role. We need to remember why we are all here today. It's to know what human beings are capable of, and to say, no, we can't act like that. And if you do act like that, well, you've got a risk at internal, domestic level and international level. And in coming 10 years, it's the political will we need to focus on and recreate.